to Immigration Q&A with Attorney Estee. I'm Attorney Estee Aceron Bisnar. I am practicing immigration law, family law, probate and estate planning here in California, and I'm also licensed to practice law in New York and Philippines. In this segment, I will answer questions about U.S. immigration law. So if you have questions, feel free to email me at attorneyestee@aceronbisnarlaw.com, and I will do my best to answer your questions through this segment. Let's get started with our question for this episode from Mr. Peter S. of Virginia. Attorney Estee, I am a U.S. citizen and I have a girlfriend in the Philippines. We want to get married here in the U.S. What is the process we should take? Thank you, Peter, for your question. The first step is for you as her sponsor to file a petition for alien fiancé or Form I-129F with the USCIS. The petition must include, of course, a check for the filing fee. At this time, it is $535, plus passport-style photographs of you and your fiancé, proof of your U.S. citizenship, either your U.S. passport, birth certificate, or certificate of naturalization. So for those watching who are green card holders who have fiancé outside the U.S., you cannot file I-129F yet. You have to become a U.S. citizen first. Also include your fiancé birth certificate and then proof of intent to marry. A simple letter from you and your fiancé stating your intention to marry within 90 days from your fiancé's arrival here in the U.S. will suffice. Proof of legal termination of all prior marriages for both you and your fiancé. You must also submit proof that you and your fiancé have met in person within 2 years before filing Form I-129F. So this is what we call evidence of in-person meeting. If you met your fiancé online and has not even seen her in person, you cannot file this petition yet because you must have personally met her within 2 years before filing. So if you intend to petition your girlfriend, then when you visit her in her home country, make sure you keep your boarding pass, plane tickets, receipts, especially if you use your credit card, and also take some photos with her and her family and friends, and if you have dates stamped in the photos, that's even better. And if you are represented by counsel, then you must also submit a completed Form G28. Now, if some of your documents are not in English, then you have to have certified English translations of any non-English documents. Once your petition is approved by the USCIS, then the second step is applying for a visa. After USCIS approves the petition, it is sent to the National Visa Center. The NVC will give you a case number and send your petition to the U.S. Embassy or consulate where your fiancé lives. The NVC will mail a letter to your fiancé with a list of actions to take to apply for a K-1 visa and prepare for the interview. Now, eligible child or children of K-1 visa applicant may also apply for K-2 visas. So what are the required documentation to the visa interview? 1. Completed Form DS-160 online non-immigration visa application. 2. A passport valid for travel with a validity date of at least 6 months beyond her intended period of stay in the U.S. 3. Birth certificate. 4. Divorce or death certificate of any previous spouses for both you and your fiancé. 5. Police certificate, or in the Philippines, the NBI clearance. 6. Medical examination record. 7. Evidence of financial support. Also add 8. 2x2 U.S. passport style photos. 9. Evidence of relationship. And of course, payment of fees. During the interview, your fiancé will be asked questions about your relationship with her, so it is advisable that you get to know each other better before the interview. For example, the consular officer will ask your fiancé about your interests and hobbies, your occupation, your parents' name, your wedding plans, your religious background, whether you understand her language, etc., etc. Now, if your fiancé passed the interview, the consular officer will give her her passport containing the K-1 visa and a sealed packet containing the civil documents she provided, plus other documents prepared by the embassy. Please take note that she should not open the sealed packet. Only the immigration official should open this packet when she enters the U.S. Once she is here in the U.S., then you should be married within 90 days from her arrival date. Thereafter, you can sponsor her for her adjustment of status so she can get her green card, which is a distinct and separate immigration process. That's it for now. So this is an overview of the fiancé visa process. Please remember, this segment is to provide information and general views about U.S. immigration law. This segment is not intended to provide specific legal advice. Every case is different, and so it is always advisable to consult an immigration attorney. You can check out my YouTube channel, Attorney Estee channel, for more information about U.S. immigration law. And for free consultation, you can email me at AttorneyEstee@AceronBisnarLaw.com or visit my website at www.AceronBisnarLaw.com. See you in the next episode of Immigration Q&A with Attorney Estee every first Friday of the month here at Spotlight TV on KSCI TV LA 18. Bye!